Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
Speaker of Parliament of Ghana, Alban Sumana Bagbin, ene, or say Omanpini, the vet and the ministers on the Abba, so Omon Veto, on suspending. Yes, so bet Omanpini, Akuffo Addo, I say, Sani gidi ne patapano or yeno. I don't know why I'm just being canasem no pay and I did be opese a year jumano. A year Alban Bagbin, our Speaker of Parliament, again how we President Flo, Vice President Flo, no and a toss on my train. Was it Akuffo Addo? Who do you bo? And ne ensure atrame. And ne upon Chelani. Since you try now, beg your war until I just war at your man. Or so, whoa, men mafia papa, Mamsa wo, muye. Ya yet Parliament, who disrespected, muye. Who fire say o ma kwala bi na odi agro. I will show you pepe. And ne, I will show you pepe. Hey, now we are the anti-LGBTQ plus bill na bro sign. O be kire ye mra e wo hanom. Wo be kire de o pe abra mra no susu e da ho. Sa ene ye be kire o mafia. E be mo hu say ye susu. Aha, ye ne ye mra no. Enti Bagbin say wa suspended Omanpini ministers or the Omabasi and Veto deputy minister was suspended no. And then ministry or a better home pines are obedient to me with a obedient to me for Juma. Sans Omanpini Akuffo to aid disrespected a year offense the Parliament of Ghana. The patapano and ne a pim. So we are so sa me pesi a koni could video no. Yeah, but today you could video no. Aye aye she honey or say wo afedie wakutia wo egbodua so memo ate openga. Yes, yanko na yanko tie ene eye de esi wo Parliament wo bra eye Alban Bagbin authority a Omanpini Akuffo Addo say no yentena se ema wonfo ye nim twitwiri fom sa efi nereko yenso ye ministry ministers Saudi Abasi and Veto ya suspended kopem se ye asino ye benya no poma tobre yanko mpacho answer no message so be subscribe to PENDREAM TV mpacho subscribe to channel no ane na like video no like e boa ma video no kwachiri ema afoforo so ehwebi yanko na yanko tie video no emra sesia.
Back from the suspension, I'm told the suspension was to be for 1 hour. It's taking longer than that. I understand why, because there were a few discussions behind the scene, the usual channels of communication. But I think it's right and proper for me to thank all of you for holding on the fort in my absence. I had to lead a delegation to attend a conference on behalf of the Parliament of Ghana, and in fact Ghana, a very, very important conference, a Global Council for Political Renewal. Global Council for Political Renewal. I had key members, including the former Majority Leader, Honorable Osei Mensah Bonsu, to ably support me at the conference. I just arrived this afternoon, and since today is the last day of the sitting of the House for this meeting, I rushed to come to support you and well. I've been given a lot of brief by leadership and my able second deputy speaker, who I'm extremely grateful to for holding on the fort. I know the first deputy speaker was very, very busy. It forms part of a series of actions that undermine the legislative process. As you may recall, I addressed this House on the 22nd of December 2023 in a formal statement. The purpose of that statement was to draw your attention to the President's refusal to assent to 4 critical bills passed by this House. 3 private members' bills and 1 public bill. During that address, I underscored the troubling nature of the President's justification for his actions, or rather, the lack thereof, particularly highlighting that his failure to assent on grounds of alleged unconstitutionality paradoxically stood in violation of the very Constitution he invoked. Despite the gravity of this matter, it is disheartening to note that there has been no progress in rectifying the situation concerning those significant pieces of legislation. They remain in a state of limbo, unreturned to Parliament, detained by him, and unacted upon, following the President's communication, which lacked substantial legal justification. This ongoing scenario poses a grave threat to our legislative authority and, by extension, the democratic principles we try to uphold. The implications of such executive actions extend far beyond the immediate legislative items at hand. They erode the foundational checks and balances that our forebears painstakingly established to ensure a vibrant and functioning democracy. When important legislative work, the product of rigorous debate and consensus building within this House, is disregarded without just cause, it not only disrespects the legislative branch, but also disenfranchises the citizens that we are sworn to serve. This blatant disregard for legislative processes and constitutional mandates risks setting a perilous precedent that could weaken the very fabric of our governance structure. Honorable members, on 19th March 2024, my attention was drawn to a letter issued by the Executive Secretary to the President, Nana Asante Bediatu, addressed to the Clerk to Parliament, which letter is clearly, in my opinion, contemptuous of Parliament. The letter outlined that the Clerk ought to, and I quote, cease and desist, unquote, from attempting to transmit the Human Sexual Rights and Family Values Bill 2024 to the President for necessary action in accordance with the provisions of our Constitution. In the said letter, the Executive Secretary indicated that the Office of the President was aware of 2 pending applications for an order of interlocutory injunction seeking to restrain the clerk and from transmitting the bill to the President. It further indicated that the Honorable Attorney General had on 18th March 2024 informed the President that he had received the 2 applications and had advised the President not to take any step in relation to the bill until matters raised by the suit are determined by the Supreme Court. As a result, the President, via the Executive Secretary, conveyed to the clerk that it was unable to accept transmission of the bill. Honorable members, my attention has also been drawn to the 18th March 2024 letter from the Honorable Attorney General being referred to by the Executive Secretary to the President, Nana Asante Video 2 above. In the said letter, that is the letter from the Attorney General, I note that the Attorney General used the phrase, and I quote, "I will respectfully advise that a decision to assent to the bill be made after the determination of the application for interlocutory injunction," unquote, and not an advice to the President not to receive the bill from Parliament. It is therefore interesting that in view of this clear and unambiguous advice from the Attorney General, which I disagree with, to the President has rather chosen to accept the bill. In the face of these developments, it is important for us as a House to reflect upon the manner in which these events have unfolded. On the 28th of February 2024, this August House took a decisive step in passing the bill, a move that was a culmination of rigorous debate, thoughtful deliberations, and the collective will of the representatives of the people. Following this, the bill underwent the customary process of cross-checking, which is an important procedure designed to ensure that all amendments and changes proposed during the legislative process were accurately incorporated. After the successful processes were done with, the Clerk to Parliament, fulfilling his duties as the procedural intermediary between the legislative and executive branches, endeavored to send the bill to the President in accordance with Section 5 of the Interpretation Act 2009, Act 792. This action, steeped in established parliamentary practice and procedure, signifies a final step in the legislative process, enabling the President to review and, if assent to the bill, thereby enacting it into law in accordance with Article 1067 of the Constitution. The refusal to accept the bill for transmission did not occur in isolation, but persisted across multiple attempts, with the third attempt to transmit the bill forming the basis of the letter I have previously alluded to. So 3 occasions to serve the bill. In fact, the Constitution used the word present the bill to the President. Failed. Notably, the President's refusal to accept the transmission of the bill has not been formally communicated to this House through the established channels of official correspondence from the President to this House. The absence of an official communication to the House regarding the President's refusal is troubling. Yet, it does not diminish the gravity of the situation, nor our responsibility to address it. No communication from the President to the House is through the Speaker. Nothing like that has been done. The contents of the letter, albeit not formally presented to us, have come to our attention, compelling us to confront the issues it raises. It is a matter of great concern that the executive branch has chosen to disregard the established constitutional structures that constructive dialogue and collaboration between the branches of government. In light of these circumstances, it is incumbent on this House to stand united in its response to this affront to the legislative authority vested in Parliament by the Constitution and the people we serve. We must articulate a collective voice that unequivocally condemns the disregard for our constitutional structures and reaffirms our commitment to uphold the rule of law. This situation calls for a principled stance, emphasizing the importance of adherence to the procedures and norms that govern our democratic institutions. Honorable members, I want to make some comments on the legal framework for action to be taken after a bill has been passed. This is important for the information of all, including the people we represent. Article 106, Clause 7 of the Constitution provides, and I quote, "Where a bill passed by Parliament is presented to the President for assent, he shall signify within 7 days after the presentation to the Speaker that he assents to the bill or that he refuses to assent to the bill, unless the bill has been referred by the President to the Council of State under of this Constitution." Section 5 of the Interpretation Act 2009, Act 792, provides 2. As soon as a bill is passed by Parliament, the text of the bill as passed shall be sent by the Clerk of Parliament to the government printer, who shall print 4 copies of the bill on vellum paper or on paper of enduring quality and send the copies to the clerk. 4. On receiving the copies, the clerk shall carefully compare them with the text of the bill as passed, and if the clerk finds the copies to be correct, shall sign on each copy a statement in the form set out in the first schedule, and shall send the copies so authenticated to the President for the assent. 5. Where the bill was passed in accordance with the relevant provisions of Article 108 of the Constitution, the clerk shall, before causing the copies to be presented to the President, submit them to the Speaker, who, if satisfied that the bill was passed in accordance with the Constitution, shall sign on each copy a certificate in the form set out in the first schedule. 6. After the assent, the clerk shall enter on the appropriate number of the act, unquote. The combined effect of these provisions read together is that after a bill is passed by Parliament, it undergoes a meticulous process designed to ensure its conformity with the nation's legal and constitutional standards before it can become law. Initially, the passed bill is sent to the government printer, who is responsible for printing 4 copies on high-quality, durable paper. Following this, the clerk to Parliament conducts a thorough verification of these printed copies against the original bill and the amendments to ensure the accuracy. Upon successful verification, the clerk authenticates each copy by signing a statement that certifies the correctness. In Article 108 matters, an additional step is introduced. The authenticated copies are presented to the Speaker of Parliament, who must certify that the bill was indeed passed in accordance with Article 108 by signing a certificate on each copy. And the honorable members, it's important for me to add this, that this issue about fiscal impact analysis is always done, and the report is always presented to me. And I read through all the reports, and I refer them to a legal person for advice. It's when I am advised that they conform to the Article 108, and I'm convinced that that advice is right, that I recommend them for processing by the necessary authorities. Final and perhaps most critical phase of the process involves the presentation of the bill to the President for assent. Pursuant to Article 1067 of the Constitution, the President has a 7-day period to either assent to the bill, signifying its enactment into law, or refuse to assent, which may involve referring the bill to the Council of State for further advice. Upon the President's assent, the Clerk of Parliament assigns an official act number to the bill, formally making it a law. If the President has concerns about the bill presented, the President refers the bill with the concerns for further consideration of Parliament. When that is done by Parliament and it is represented to the President is by law bound to assent to the bill. That is what is in the Constitution. Ghana, the President has no power of veto. Honorable members, I now make comments on the injunction applications and their effect on the law-making process. Honorable members, this House has been duly served with 2 injunction applications in respect of the bill. The applications titled Richard Sky versus the Parliament of Ghana and the Attorney General, and the second, Dr. Amanda Odoi versus the Speaker of Parliament and the Attorney General. Honorable members, You will recall that on the 19th of July 2023, the Supreme Court considered and dismissed an application for interlocutory injunction that sought to injunct the proceedings of Parliament in respect of the bill. The court in that case, Dr. Amanda Odoi versus the Speaker of Parliament and the Attorney General, J1/13/2023, reasoned that the application failed to meet the threshold for the grant of interlocutory injunctions. The Executive Secretary to the President noted in his letter that, and I quote, "It is settled law that during the pendency of an interlocutory injunction application, the status quo ante ought to be preserved and no action be taken that will result in prejudicing the injunctive relief sought and undermining the authority of the court," unquote. Honorable members, an injunction is a judicial order that restrains a person from beginning or continuing an action that threatens or breaches the legal right of another, or that compels a person to carry out a certain act, such as correcting a wrongful state of affairs. In the context of our law, interlocutory injunctions serve as an important tool for maintaining the status quo pending the resolution of a legal dispute, ensuring that the parties involved do not engage in actions that could cause irreparable harm or fundamentally alter the situation before the court as an opportunity to decide the case. I won't want to go into the law on injunctions because these two cases are sub judice. But it's important I say a few things. The act of transmission of a bill to the President merely represents the procedural progression of a bill within the structured framework established by the Constitution. It does not, in and of itself, guarantee the bill's enactment into law, as the President is accorded the authority, as clearly outlined in the Constitution, to either assent to the bill or refuse it under Articles 1067 and 1068. And he can refer to the Council of State for advice or refer it back to the House for reconsideration. Additionally, in the event that a bill is assented to by the President and becomes law, the Constitution provides a mechanism for judicial review. Articles 2, Clause 1 and 130 empower the Supreme Court to scrutinize the constitutionality of an act of Parliament. Should the court find that the law is unconstitutional, it possesses the authority to invalidate the act. Given these considerations, it is evident that the transmission of a bill to the President for assent does not result in irreparable harm that will justify the granting of an injunction, much less the halting of parliamentary process on account of the application of an injunction. Generally, the Supreme Court has upheld the position of the law that the official acts by organs of the state and government departments are presumed to be regularly performed unless there is strong evidence in rebuttal. Arising out of this, it is imperative to note that the courts have been very reluctant in injecting and placing impediments on arms of government and constitutional bodies from performing their constitutionally mandated duties. This has always resisted attempts to unfairly and unsuccessfully place a clock on the work of this House through the use of injunction applications. In Welford Kweku versus the Attorney General, the Supreme Court, per Dr. Datiba JSC, noted that, and I quote, where the relief sought relates, as here, to a public law matter, particular care must be taken not to halt action, presumptively for the public good, unless there are very cogent reasons to do so, and provided also that any subsequent notification of the impinged act or omission cannot restore the status quo. Given the reliefs that the plaintiff is seeking in the substantive suit in this case, it is clear that if he succeeds in securing the declarations he has claimed, the impugned provisions of the Local Government Act 1993, Act 462, will be declared void, and any actions made in pursuance of that nullified. Accordingly, no irreparable damage will have been caused the plaintiff during the period between the issue of the rent and the date of judgment, unquote. In Dr. Amanda Odoi versus the Speaker of Parliament and the Attorney General, the court refused to grant the injunction application because no prima facie case had been made to restrain the work of Parliament, and further, the applicant was unable to prove irreparable damage should the work of Parliament continue in respect of the bill. This same bill we are talking about. The court's cautious approach in dealing with injunction applications against parliamentary processes further underscores the importance of not hastily impeding the legislative functions of Parliament. The precedents, as I've just set out, show that courts have been slow to grant injunctions that will have to halt the work of Parliament, recognizing the profound implications such actions would have on the legislative autonomy and the balance of powers within the government. The judicial reticence is rooted in the recognition of the fundamental principles underpinning a democratic society, where each branch of government operates within its own sphere of influence, with specific duties and powers that are designed to complement each other, ensuring a robust system of checks and balances. The courts, in exercising their discretion in matters of injunctions against Parliament, demonstrate a careful consideration of these principles, opting to intervene only when absolutely necessary and when the legal threshold for such interventions are unequivocally met. Honorable members, it's time for reflective conclusion. Several critical points emerge that underscore the importance of adhering to constitutional and legal frameworks within our democratic governance. Firstly, the President's refusal to accept the transmission of the bill is, by all accounts, not supported by the constitutional and statutory provisions that guide our legislative process. The Constitution clearly delineates the steps to be followed once a bill has been passed by Parliament, mandating the transmission of the bill to the President for assent or rejection. Therefore, the refusal to even accept the bill for consideration falls outside the legal bounds established by our constitutional framework. It is incumbent upon the President to accept the bill and take the necessary action within the prescribed constitutional limits, whether that action is assent, refusal, or referral to the Council of State for advice or Parliament for reconsideration. It is instructive to note that the Executive has in the past proceeded with its actions, although there has been pending before the court injunction applications against the state. Secondly, there must be a steadfast rejection of any attempts to unduly fetter or hinder the work of Parliament. The Parliament of Ghana operates as a crucial part of our democracy, embodying the will and voice of the people. Parliament embodies the sovereign will and power of the people. Parliament embodies the might and majesty of the people. And as I keep on saying, the power of the people is stronger than the people in power. Any efforts to obstruct its work, Parliament's work, disrespects this fundamental institution and threatens the principles of governance by consent and representation. Thirdly, it is imperative to remain vigilant against certain dangerous precedents that could potentially undermine the foundation of our democracy. The rejection of a bill's transmission without constitutional basis introduces a precarious deviation from established democratic practices and norms. Such actions, if left unchallenged, may embolden future attempts to circumvent the legislative process, thereby weakening the integrity and efficacy of our democratic institutions. Lastly, in alignment with our constitutional mandates and the principles of good governance, it is essential for the President to adhere to the lawful course of action by accepting the transmission of the bill. Upon receipt, the President has the constitutionally provided options as to what to do. I don't want to repeat it here. As we move forward, it is the collective responsibility of all branches of government and indeed all citizens to uphold the Constitution and ensure that our democratic processes are not only preserved but strengthened. The current impasse presents an opportunity for reflection and reaffirmation of our commitment to the principle of democracy, rule of law, and the unequivocal respect for the legislative process that forms the bedrock of our nation's governance. Honorable members, the Parliament of Ghana will comply with the existing legal frameworks and reject the attempts by the Executive Secretary of the President through his contemptuous letter to instruct the Clerk to Parliament, an officer of Parliament whose position is recognizably under the Constitution. We shall not cease and desist. Be that as it may, honorable members, I also bring to your attention the receipt of a process from the courts titled Robson. Honorable member, I'm watching you. And I hear what you say. Be that as it may, honorable members, I also bring to your attention the receipt of a process from the courts titled Robson Nelson Eche K. Dafiamapo versus the Speaker of Parliament and the Attorney General, suit number J1/12/2024, which process was served on the 19th, that is yesterday, March 2024, and an injunction motion on notice seeking to restrain the Speaker from proceeding with the vetting and approval of the names of the persons submitted by His Excellency the President until the provisions of the Constitution are satisfied. Honorable members, in the light of this process, the House is unable to continue to consider the nominations of His Excellency the President, to use the language of the Attorney General and Minister for Justice, quote, in the spirit of upholding the rule of law, unquote, until after the determination of the application for interlocutory injunction by the Supreme Court. Honorable members, this is the precedent that is being set by His Excellency the President for all Ghanaians to follow. So any matter that comes before Parliament, any Ghanaian can issue a writ and follow it with an application for injunction, and that is enough to injunct Parliament from proceeding with the consideration of the business in the House. Honorable members, I thank you all for your attention, and may God bless our homeland, Ghana. Honorable members, members, I now proceed to adjourn the House sine die. The House is accordingly adjourned.
Presence with all our will, and my forevermore. And our story is our presence with all our will, and my forevermore.
You, anti-Speaker of Parliament, Honorable Sumana Bagbin, ono ena yakofa nano di nsem ede abremo ewo PENDREAM TV so na mwankasa esomani eye speaker wakasa na mwamutie nsem a speaker kan yi no wakyerɛkyerɛ asɛm no ama mwate aseɛ ane wakyerɛkyerɛ asɛm no ama mwate aseɛ enti ehu hia sɛ mekasa kasa tenten bia just a brief talk. Just a brief talk. And I made the babam said the bear obeti Jumadi no ase ne die intira die a course no a course. Ane Speaker of Parliament wapapa mu. Also Oman Pegini Akuffo Addo na setting the precedence. And you be a say emra wunim say Parliament hyehyɛ ne mra. Biara need to me and a court biara need to me say obe or the injunction beto parliament so it is a wo omanpanyin no wadi kan abie saa ekwan no say obi the injunction ekoto anti LGBTQ+ no so enti wo no on sign wo ansenti to bill a omo ajetum o parliament ho na say obebu emra so no ahwe de unim se ade ne nyemra na wadi akiri dia then de ne yenso ye ka kire no se obi soso de eye injunction aba ti so obi de injunction aba dia then ono Speaker of Parliament by the power vested in him by the Constitution of Ghana ono so the suspension eto so o ministers awodi o maba say yenye den yen Veto o mo so or the suspension at so until say nsam ni abekwa koto no ono speaker oma ho kwan emu obi ambeti ministers no and the ministers no yes ya yimu ya apalmo and ye mo bebo fie sa untimi nya adwuma bia unnim na ukoyi adwuma bi ukoma command bi ukoma instruction bi ukoyi 1 cd ma ne koyi adwuma oba bi utiate cause unya sa tumi no unnim na ukobo hu musuo ekoye sa de ni bi utirate so when your problem when your issue na che say wo no say contempt of parliament aban bia betimi achiwatum amana yiye because krono na okoboy tumi bia ni unni tumi bia enti omampanyini na akofa aba ti yemmodu dondo no emmo no ankasa no no ankasa ensa parliament ene omakasa ti asam no said ye nkyerase pa tie na te ase yi Mebe kyerɛkyerɛw ensɛm binom ɛnɛ nsɛm a asi wɔ parliament no ɔba mpanyina Akuffo Addo ɔso wɔ so na foforo ɛnɛ do ɔde akɔforo baabi ani kwa baabi yɛmforo na nɛ adedere na ankasa ne ho afa no ankasa ɛyɛ speaker of parliament ɛnɛ wɔ parliament wakyerɛ ɔmampanyini Akuffo Addo sɛ look saa wɔ pata paa no ɛne nana yɛ nkamasɛm no ɛne wo deɛ wo pɛ no na ɛwɔ sɛ ɛyɛ adwuma. You don't care about any shit. You don't care about obia decision. You don't care about obia sɛ adeɛ no yɛ mmara sɛ ɛnyɛ mmara sɛ ɛyɛ constitutional sɛ ɛnyɛ wo no Akuffo Addo no nea wohwehwɛ no ɛno na wopɛ sɛ ɛyɛ adwuma. This time around ɛyɛ Bagbin ɔsɛ ɔmma ɛnyɛ adwuma biem ɔsɛ ɔmampanyini Akuffo Addo it won't work again. Me pese me kyerɛw ntɔkwa no ɛno nienti antɔkwa no aba a ɛnɛ speaker of parliament atoto bi ama ɔmampanyini Akuffo Addo a waka ntam sɛ ɔmampanyini Akuffo Addo ɛfɛn sɛ ministers a ɔde ɔma ba for vetting si yɛn vɛte ɔmo na yɛma ɔmo kwan ma ɔmo ɛnkɔyɛ adwuma wɔ ɛyɛ ministries ni bi no parliament so edi tabo ato so ma suspend saa ɛyɛ ministerial appointment no they are not going into it, they won't pass it enda ho kopem se nie ebesi no ensi me pese me kyerɛkyerɛ mu na wo hu nie ntira saa ntokwa no asi mo kai se na nsin a ɛna anti LGBTQ plus bill no yɛde kɔto parliament anim parliament doso mu wura mu kyerɛkyerɛ adwen toato adwene make sure sɛ ɔmo bɛhwɛ ama mmara no atumi aba na ɛba so a atumi abɛserve ne purpose nti a ɛwɔ sɛ ɛba na for the first time our parliament both the minority and the majority went into consensus ɔmo nyinaa gye to mu sɛ saa mmara ɛyɛ anti LGBTQ plus na yɛdeɛ yɛsɛ Ghana ha yɛmpene emma sɛbe ɔbarima nkɔfa ne yɔnko to na ɔba nkɔfeefe ne yɔnko ase na ɔbarima nsɔre sɛ ɔno deɛ mepɛsɛ me ware kraman ɛnkɔfa kraman sɛ ma ware kraman ntimi deɛ me ne kraman na ɛbɛda na ɔfa kraman turumu anaasɛ kraman baabi na ɔbaa so ɛnkɔfa kraman sɛ me deɛ kraman na ɛyɛ me so me kunu enti makɔ ware no enti mɛma ho kwan ma kraman ne me ada saa nsɛm hunu no ne saa mmoasam no ɛyɛ parliament of Ghana sɛ Ghana ha yɛmpene yɛnsosɔ so ɔmo nyinaa gye tumu ɔmampanyini ne MPs ɛwɔ parliament MPP MPs ɛwɔ parliament ɛne NDs MPs ɛwɔ parliament ɛnyina ka bɔ mu sɛ yɛagye atum sɛ saa mmara wi ɛnyɛ adwuma na mmara no ɛkyerɛ sɛ at the moment a mmara bi ɛbɛba parliament no mbɛdoso mu ahwehwɛ mu make sure sɛ ɛyɛ na ɔmo paase ne sɛ wum yɛwɔ number of days bi a yɛde ma ɔmampanyini na ɔmampanyini a wɔte agua no so no na wɔasɛnte ne signature de ato aseɛ a ɛbɛkyerɛ sɛ afei deɛ ɛyɛ saa mmara no abɛyɛ mmara a yɛde di nipa biara ma no yɛ yie sɛ wansan a ɛnyanyɛ mmara enti parliament awie ne deɛ yɛatabiri ɛyɛ saa mmara yi ɛde akɔ ɔmampanyini Akuffo Addo na kakye sɛ nka ɔnhwɛ mu na afei ɔnsan na ɔmfa mmara na afei adeɛ ne ɛnyɛ mmara yɛde kɔɔyɛ a ɔmampanyini Akuffo Addo sɛ ɛhene fa memfa me nsa wi nsɔpɛ mu ɛmfa nsi anti LGBTQ na mensan dabi I won't do that dabi menyɛ na nienti a ɔmampanyini Akuffo Addo ɔso ɔnyɛ no na up till now ɔnyɛɛ no ɛne sɛ ɔmampanyini Akuffo Addo me pɛsɛ kyerɛkyerɛ mu na sɛdeɛ ɛbɛyɛ kasa na ɛba no wate kasa na se yie ne deɛ ɛyɛ ɔmampanyini ɛfɛ sɛ speaker of parliament ka hɔ ɛyɛ parliament no wate aseɛ ɛyie enti ɔmampanyini sɛ ɛda ne yɛde kɔma no wate sɛ obi sɛ ɔkɔ ɛyɛ parliament na sorry wɔkɔ court Supreme Court na ɔde tabo akɔto saa fɛn sɛn bill no so sɛ ɔmpene mmɛyɛ mpaase bill no enti ɔtwɛn ama nipa no akwansa na nipa no de wei na akɔto so na watwɛn ama court no ahwehwɛ mu ansa na ɔno ɔde ne nsa ahyɛ aseɛ which mmara no so ɛnkyerɛ saa mmara no ɛse sɛ parliament hwehwɛ mu wie a parliament agyi to mu wie a it is kyerɛ sɛ ɛyɛ correct ɛwɔ sɛ yɛtam na yɛde brɛ wɔ mampanyin na ho sign sɛ obi wɔ problem bi wɔ mmara no mu baabi a ɔde kɔ Supreme Court na Supreme Court arefɛ saa mmara no ɛde abrɛ ebia parliament sɛ mo make amendment we ne bia saa mmara we ni we ebia ekotia ebia first the constitution no yɛ wafa bi wɔ hɔ no mu a saa mmara ya mo hye ha ekotia ha aha kotia nti mo nyɛ amendment nti no ɛno no ɛyɛ amendment ne yɛbɛyɛ yɛntimi nka sɛ me yɛ sign there be Supreme Court ko ni saa tumi no so mbɛka kyerɛ parliament sɛ parliament ahyehyɛ mmara bi na ɔmo pɛ sɛ ɛyɛ mmara ɔno Supreme Court bɛka sɛ there be saa mmara we ma mo pass they don't have that power because mmara no constitution ne sɛ nkrɔfo a yɛma ɔmo hyehyɛ mmara de mmara ba constitution no parliamentarians ɛna ɛhyehyɛ fɛnsɛ constitution no ɔmo asɛdeɛ no ɛnyɛ Supreme Court deɛ ɛne judges no ɔmo interpreti ɛyɛ mmara no ɛma yɛyɛ te aseɛ because ɔmo wakɔsua mmara enti ɔmo interpreti they are interpreters of the constitution enti ɔmo ni tumi sɛ odwuma ɛkɔ so ɛwɔ parliament no ɔmo bɛyɛ den ɛbɛtena hɔ sɛ ɔmo ɛba bɛ challenge saa adwuma no ɛna wo Akuffo Addo sɛ twɛn ama saa nkrɔfoɔ no ɛyɛ Supreme Court akyerɛ wo deɛ wonyɛ ansa na wasan which ɛnyɛ mmara enti wo nsan ɛna ebinom kyerɛ sɛ ɔbrɛ a ɛyɛ ɛfɛn sɛn what do you call it e-levy ɛbaayɛ na mo san yɛ parliament G2 mu NDC parliamentarians minority no ɛkɔ court kɔgye injunction po de to so sɛ ɔmo mpene me yɛ mpaase ɔmanpanyin Akuffo Addo antie ɛda na ɔde ne nsa ɛto ɛhyɛ aseɛ na ɔsan yɛ na wei deɛ aba na ɛyɛ anti LGBTQ+ ne yɛse sign na ɛmɛyɛ mmara ɔmanpanyin sɛ ɔtena ase atwɛn ama obi akɔ court na court no fra asɛm no na ɔkyerɛkyerɛ asɛm no wie a ansa na ɔno ɔmanpanyin Akuffo Addo no ɛde ne nsa bɛhyɛ aseɛ meanwhile adeɛ no nya mɛyɛ mmara enti ɛyɛ Supreme Court no ɔmo ni saa locus no mpo sɛ ɔmo bɛhwɛ mmara no mu ɔmo nyɛ mmara no ɛnya mɛyɛ mmara ɔmo no ɛbɛyɛ mmara a ɛna ɔmo betumi ahwɛ mu ɔmanpanyin Akuffo Addo so ɔnyɛ ɛno ɛna ɛnɛ Bagbin Sumani Bagbin ɛnɛ ɔse sɛ nsuo taa pɔnkyerɛne a ɔgye wɔ anɛ deɛ ɔbɛkyerɛ Akuffo Addo ama Akuffo Addo ahunu sɛ saa deɛ ɛnyɔm a ɔyɛ na nyɛ so ɔntimi nyɛ bio obetumi ayɛ papa obetumi akyerɛ ne mafia obetumi amafia na ama na hu sɛ yes ɔno so wɔ tumi a mmara no constitution no ɛde ama na ɔyɛ ne number 3 person ɛwɔ Ghana ha woyi president fi woyi vice president fi ɔno ɛna ɛwɔ hɔ a ɔno so mmara na ma ne tumi na mmom sɛ ɔman no ɛbɛkɔ yie nti ɛna sometimes ɛyɛ no wɔyi n'ani no wɔhwɛ na nyɔma bi ɔmanpanyin fi sɛ ɔyɛ smart anana ne koko yɛ den ɛna obubu fa so na mmom ɛnɛ ɔmanpanyin akɔka deɛ nka nti ɔbɛkyerɛ no ama na hunu sɛ saa kokoti ne tuunu na wɔyɛ no saa gidigidi na wɔyɛ no ɛnɛ ɛbɛte n'ani so enti ɔno so ɔmanpanyin ministers ɔde ɔmo abase yɛn Veto ɔmo no parliament so ade suspension ato so ɔmo so de suspension ato so because obi so akɔ court ɛso ɛde injunction akɔto so enti ɔmo so no ɛde fɛnsɛn ɔmo suspend ɛyɛ Veto na ɔmo yɛ no And as omo vete sa ministers na there is no way minister be able to make akowura offense offense ministry be am akoye adwuma because unni sa tumi no until say your friend is saying parliament be veto ni ya approve say afedi adwo atumu no unni sa tumi no nti ene ama omanpanyina Akuffo Addo so ne nsa konkom
ya mobo wo Ghana etisika so o menya ohia man nenam amamu a enkoyie nti no ekom de
the country where I come from, the truth is ironic, just like animal farm. Justice mean inequity, so who go say the truth? Who go say the truth? Christian can say silence, Islamic leaders silence, kings and queens silence, traditional leaders silence. So who go say the truth? We are them go get so confused the call. Now by area why no better. We are them go get so confused the call. One guy's oh yeah why no better. Who go say the truth? Who go say the truth? Oh, he need it now, see what's I see so. Now your friend on a nine camasam. Only papi obeka nice and beer. So I'm to one bet you were two. Everybody was afraid. And when Tina to my cottage, I nine. Once my boy dumping one and but who go tell the truth? Nanai or say me. Nanso bien person beka wasam because everybody is afraid. Anya safwe muayini. Akuku drofo nyina dalima. Enti who go say the truth? Obiadra konson so to grow your man set to me be a kakobrafo. Efo anyina ye. Efo when you know yet. Na so kutrata down na so be dia back or why no keke. I fene for be man mo pia for efo ne cross on my mo. Hanya safwe mo ayini. Akuku trofo nyina dalima. Enti who go say the truth? Abaya di bote chino. Yedi bi bebo nyande bi kachi sa wodi o ma o pipi numa wodi o ma never shine my frafonsa. But who go tell the truth? TUC silence, even journalists silence. Oh, then who go say the truth? Right is right. Wrong is wrong, no matter how you justify. You say you wanna get rid of corruption. Someone want to help you, now the person become your target. Jobless no they mean senseless, poverty no they mean useless. One day them go resist.
Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo. Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.